Hello, my name is Desmond Cole. I'm a freelance journalist, activist, and author. Legal Aid Ontario has taken the serious and unprecedented step of defunding the African Canadian Legal Clinic, or the ACLC. Now, while ACLC will continue to operate, its reach and its impact will be significantly reduced. Legal Aid Ontario has asked me to help produce this video to explain its decision to defund the African Canadian Legal Clinic. I have no prior or ongoing relationships with Legal Aid Ontario that I believe would compromise this work, and I'm not being paid to do this work. Joining me today to help explain the defunding decision is Julian Falconer, a human rights lawyer and the counsel retained by Legal Aid Ontario in this matter. Hello.
Good afternoon.
Now, Julian, Legal Aid Ontario made its decision to defund the African Canadian Legal Clinic in August of 2017, but LAO has had concerns about management of the African Canadian Legal Clinic going back to at least 2009. Can you just explain how these concerns started and how they've progressed over these years?
Issues around the accounting and management practices at ACLC started to surface certainly as recently as 2009, to the point, sadly, in 2010, the two lawyers that sit on the ACLC board resigned and sent letters indicating their concerns with the financial practices at the clinic and the lack of accountability by ACLC.
They resigned from ACLC, but they sent letters to Legal Aid Ontario.
That's correct.
Okay, sorry, go ahead.
No, and that prompted more questions, and in the end, in 2010, PricewaterhouseCoopers was retained, the forensic auditors, and they went in, and over 2010, 2011, an audit takes place. What surfaced were a number of very serious concerns, and all of that was presented to what's called the Clinic Committee. So there is a clinic committee that is basically a hearing board, a subcommittee of the board of directors of Legal Aid Ontario. And they sit as a hearing board in which they hear from legal aid staff and they hear from ACLC and their lawyer. And then this hearing board makes a decision. All of those decisions that they ended up having to make dating back to 2014 through to now, there's 5 decisions, are all on LAO's website. The long and the short of it is, sadly, everything from unauthorized bonuses, unauthorized overtime claims, purchases of diamond rings that remain a mystery today, usages of the ACLC credit card, cash advances that to the tune of $6,600 that remain unexplained, $39,000 in cab fares. I can't emphasize enough that questions arose that would be asked of any of the 76 clinics, and of course they were asked of ACLC to explain these things. And as you can see from the August 2017 decision, but dating back to the September 2014 decision, they were not explained. They were not explained to anyone's satisfaction.
I want to talk specifically about the decision around ACLC, but I want to first give some context around Legal Aid and its relationship with the organizations, the legal clinics that it funds. So, first of all, who funds Legal Aid Ontario to give this money to legal clinics?
Well, frankly, Desmond, you and I do, the people of the province of Ontario. So Legal Aid is a publicly funded by the Ontario government. It's a publicly funded separate organization designed to meet access to justice needs of the people of Ontario.
The money in question that we're talking about here is public money given to legal clinics in Ontario.
Absolutely.
Now, this very serious decision to take away Legal Aid Ontario funding from the ACLC is based on something called the Legal Aid Services Act. Does this act apply equally to every legal clinic in Ontario?
Absolutely. The criteria and the dispute resolution process that applied to ACLC is applicable to any clinic. I mean, it's important to understand the vast majority clinics and clinic committee heads, directors, are unsung heroes. I mean, the work they do in helping the most vulnerable members of our communities is literally unparalleled in terms of its effectiveness and its importance. So this is a sad time and not reflective of other clinics, but the same rules apply for everybody. And really, at the end of the day, when you hear things like $120,000 in bonuses for the executive director, a diamond ring, credit card being used at a lingerie store, I mean, these are obviously troubling findings in the audit. And it's important to appreciate that the Price Waterhouse audit was conducted in the strangest of circumstances. The executive director insisted that she be present for every interview of any employees, including the bookkeeper and the board members. That is, she would not permit Price Waterhouse to conduct interviews without her being present. Very strange, and so obviously alarm bells are set off, and they would be set off for anyone. The problem here is that there seems to be a challenge in convincing ACLC, and particularly their ED, of the necessity of accountability. And so we are left in the circumstances, LAO is left in the circumstances. It isn't in charge of the clinic. It doesn't manage the clinic. The clinic is independent. ACLC is independent. As a funder, though, LAO is responsible to make sure that its funding dollars are accounted for. And the only right it has, the only power it has to enforce that is to withdraw the funding if nothing else works. And that's where we're left today. They've withdrawn the funding.
Now, Julian, regarding this issue of bonuses, there's a question of $170,000 in bonuses. $121,000 was paid to Margaret Parsons, the executive director. If Margaret Parsons, as executive director, says that she worked extra and required this money as compensation, that the clinic was short-staffed, and that she and others who were paid these bonuses as a result of making up the work were deserving of that money. What's your qualm with that? What's the problem with that explanation?
The way an audit works is that an audit raises questions which need to be answered. So when the Price Waterhouse auditors saw $170,000 in bonuses, they naturally sought this appropriate supporting documentation for those kinds of numbers being approved in the very time period that ACLC is reporting a deficit.
So during this 4-year period of these $170,000 in bonuses being paid, at the same time ACLC is running a deficit?
Correct.
Okay.
When they looked for paper and justification, they asked for all board minutes. They could find no evidence, no support for the approval by the board of the bonus payments. $121,000 of the $170,000 went to the ED. Later, ACLC, through its lawyer to the hearing board, said, well, the board did approve it, but they approved it in-camera confidential meetings, but they never produced the minutes. To this day, those approvals have never been produced. Anyone who understands how difficult the job for the legal aid clinics is, anyone who understands the unsung heroes who do this work appreciates that it is true that they put in long hours for vulnerable members of society. You will not find another clinic that is dishing out $170,000 in bonuses, and you will not find another director of a legal aid clinic that collected $120,000 in bonuses. So at the end of the day, you can't doubt or deny that people work hard. Unfortunately, the reality of a legal aid clinic is it works in an austere environment where it is difficult, if not impossible, to follow the legal aid directives and pay these kinds of numbers out. So obviously these raise serious questions, and the finding by the hearing board, the clinic committee, the finding was that ACLC could not demonstrate there had been approval, and it certainly wasn't in compliance with any LAO policy that covers the funding for the clinic. So at the end of the day, you can say that unauthorized funds are justified because we earned it, but that doesn't make them more authorized. And what does that do for accountability? And that's the challenge here.
The issue of use of taxis, city taxis by the clinic, was also a big part of this audit, and it uncovered that in a span of 4 years, again, almost $40,000 was spent by the African Canadian Legal Clinic for taxi services in the city of Toronto. Most of those services, according to the audit, were trips inside of the city, and many of those trips were to residences of staff, including the executive director. What is particularly problematic to you about the fact that that much money was spent on taxis?
$39,000 on cabs in the GTA area in a relatively short period of time is absurd. I have to tell you this, that these are logical questions any funder would ask. All of this is to say that these are sort of what I would call tragic realities around what is supposed to be services and funds going to help vulnerable members of communities that need help when it comes to the justice system. And so it doesn't matter which topic we're talking about: overtime, bonuses, taxis, diamond rings. If we are to make the system accountable on issues of race the way I would like to think my life's work is directed at, we have to be accountable ourselves.
Now, another one of the very troubling findings of this audit has to do with several $1,000s in unexplained credit card expenses. Now, you've mentioned the diamond ring. I know people have been talking a lot in the public about a diamond ring that was purchased using the ACLC credit card by the executive director, Margaret Parsons, but I actually just want to read some of the other items from the report here because it's not just about one purchase. For example, at Lavalife, the online dating site, there are expenses for gift certificates to the Scarborough Town Centre, lingerie at La Senza, spa payments, all of which are unaccounted for. There are almost $4,000 of unexplained visa purchases from places like Best Buy, Walmart, Rogers. There are alcohol purchases here. I'm not understanding how a board of directors, which oversees the expenditure of a clinic, could allow all of these different purchases to take place. You could say that one employee was responsible for this or one individual was doing it without anyone else knowing, but how is it possible that an entire board of directors would not be overseeing and scrutinizing these kinds of expenses?
It's important to understand, and pages 15 to 16 of the September 2014 decision set this out. It's important to understand, first of all, that it is because of the poor record keeping, because of the absence of records, it is not clear who at ACLC spent these funds because there is no way to trace them. So it's important to understand the distinction between that and, for example, the diamond ring that Ms. Parsons says she herself bought. Okay. But secondly, I think the bigger challenge with all of this is exactly what the two board members of ACLC, the two lawyers who resigned, said. They said in their letters, and it's reflected in the September 14 decision, they said that they kept being told, just trust the executive director. Just trust the executive director. That seems, according to the two lawyers who resigned, to be the philosophy. Just leave it to the ED. Obviously, from a governance point of view, that's highly problematic. And, you know, at its heart, there is something that is an awful truth about this entire saga. And that is, it almost feels like our community is less entitled to advocacy, less entitled to a robust demand for accountability. And so a clinic half operates, and that's good enough I don't think that's good enough. And it's upsetting to me that it's taken so long to bring this to a head, to make it this transparent. I think at its heart. I should just be a cold technical lawyer who reads to you decisions. But we have to ask ourselves, at some point, aren't we responsible if we simply turn a blind eye to this? Don't you, Desmond Cole, don't I, Julian Falconer, don't we have to start to own this? If this is okay, if this is good enough for our communities, then aren't we partly responsible for this? So I kind of ask the rhetorical question, at what stage do we say our community deserves better?
And now, specifically with this issue of the diamond ring, which has gotten a lot of publicity, that was an expenditure of $754 from the diamond shop. And Margaret Parsons, the executive director, says that she actually repaid that expense for herself the same day that it was charged to the credit card. And more recently, a receipt has actually appeared in the media, which apparently was the receipt for this expenditure. So why was the audit not satisfied with the explanation given for how this ring was paid for and why it was used under a company credit card?
The saga around the diamond ring is, I think, sort of a really sad commentary about the struggle to make this executive director accountable. It starts with the obvious, which is Price Waterhouse, in doing their forensic audit in 2010, 2011, see that a 2007 purchase was made of a diamond ring. And they ask questions, and the executive director at the time tells them, and it's reflected in their statements, tells them that yes, she purchased it, but she gave the money back that day in cash from a cash withdrawal to the office manager. She could not remember the name of the office manager she gave the cash back to at ACLC. When a simple request was made by Price Waterhouse for her banking information that would reflect her withdrawing the money and giving it back, she refused. Her lawyer said at the time that it was insulting to the executive director. This stalemate over an obvious question about the diamond ring continued for a number of years until after the defunding decision by the clinic committee, the hearing board.
Yes.
And please understand that there is media coverage over this issue previously, and obviously it's reflected in the decision several times over, both the September 2014 decision and the June 2016 decision, both decisions on the LAO website. Despite this repeat of this issue, after the August defunding decision of this year, for the first time, the ACLC's executive director, Ms. Parsons, produced a handwritten receipt. It is odd that she would have a lawyer, that this much debate over this issue would happen over this length of time, and for the first time, years later, since these questions have been asked, at least 6 years later, a receipt has floated from the sky. We do not know. There is simply a big question mark. We don't understand it, and so it reflects, yet again, very troubling incongruities, difficulties, non sequiturs, and so that's how we're left. I have no idea what the significance of that receipt is. I have no opinion because I'm not a forensic auditor. What is interesting is that none of this was provided to Price Waterhouse.
Julian, a lot of the reaction that I've seen in community about the decision to defund African Canadian Legal Clinic, a decision which Legal Aid Ontario has never taken with any other clinic, is that this is overkill. That this is an overreaction to a problem that could otherwise be solved by potentially removing the executive director, by potentially removing leadership at the board who were not living up to the mandate of the organization and of Legal Aid Ontario's requirements. Why is this kind of drastic measure of defunding by Legal Aid taking place instead of looking at those other options of potentially replacing the leadership and starting over again?
The decision of the hearing board, the clinic committee decision to defund, is the only tool that LAO has. The clinics, each clinic is independently run, and LAO is a funder but has no management or right to take over the clinic. In the case of African Canadian Legal Clinic, those in the community, of whom there are many, know there's been a long history of a struggle with this particular executive director. And the idea that you could somehow engage in a constructive effort to wrest control of this clinic is completely unrealistic and, in my view, unhelpful. The direction taken, which is to rely on an advisory committee on a go-forward basis, an advisory committee that has nothing to do with the defunding exercise, but an advisory committee made up of prominent members of the African Canadian communities who we trust to give us advice on the creation of a new clinic with a new mandate and a mandate of accountability seemed frankly a no-brainer compared to the what would become the most divisive, unseemly exercise in attempting to wrest control of a clinic for which LAO is not allowed to exercise that kind of control. They can either fund or not fund. I also want to emphasize something else. When I used the word personal before, and I repeat it now, it's because, of course, with the anxiety levels, we've seen on social media various attacks on advisory committee members, allegations of conspiracy, questions on open public radio about my blackness. I've got a thick skin. I've got 28 years as a trial lawyer. I can take it. It's unfortunate, but we either are prepared to own this problem and own fixing it, or we're not. There are two people who have inspired me in my work. They have completely different styles, and I would never taint their memory by suggesting that I'm up to the standards they created. But Charlie Roach and Dudley Laws are two people I respect and respected in an unlimited way. I use them as a beacon, as an example of accountability, and I think and believe that we have to stay at it, and we have to insist that our communities are as entitled to accountable, effective advocacy as any other community, and that settling for second best or third best or fourth best isn't good enough. And so that's what this is about. And so the unfortunate and difficult and awkward work has to be done.
Julian, thank you very much for this.
Thank you.